Hello, students. This is Attorney Sharice Woods, your instructor for the criminal law course for the summer 2020 semester. As promised, I am going to deliver lectures for you on the chapters from your first week of readings, which would be chapters 1, 2, and 3. I don't intend on providing full on, detailed, full lectures for each chapter. However, if I do think that there are some topics or some issues in the chapters that require more detailed explanations, then I will provide lectures for them. I want to remind you that these lectures are simply to reinforce the topics that you read. They are not to serve in any way as a substitute for your readings. You will be tested on your readings, which will contain information that may not be in the lecture. So, in other words, everything in your reading is fair game for a midterm examination or a final examination. Your studying for midterm exams and final exams should not be limited to the information that I provide to you in the lectures. With that being said, please consider these lectures to be merely a supplement, not a substitute, for your readings. I would also urge you to please email me with any questions that you may have if you find that even after listening to my lecture and reading your materials, you still experience confusion. All right, now let's begin with chapter 1. Your book starts with the basics of criminal law, and it states that criminal law specifies what behavior is illegal, what punishments are available, and what defenses can be invoked, whereas criminal procedure covers more of the rules and guidelines in criminal law describing how an accused is processed through the criminal justice system. We will not touch in depth on any criminal procedure issues because there's a separate course, at least that's the case in law school. There's a separate course for criminal procedure. So there may be some aspects of criminal procedure that we may cover, but for the most part, this course will focus on criminal law. There are torts. There's the law of torts. A tort is a private wrong or injury. And unlike criminal matters, torts are oftentimes seen in civil matters where the case is typically for monetary damages. So in a tort action, which is a civil case, the plaintiff is filing a case against the defendant with the hopes of getting some kind of monetary compensation in the end for some kind of injury that they have suffered. Whereas in a criminal proceeding, the ultimate penalty will not be monetary damages. It will oftentimes be incarceration. There's a classification of crimes based on the potential punishment. So the type of punishment, the length of the punishment is what ultimately determines whether a crime is a felony or a misdemeanor. And your book highlights this very clearly. A felony is a crime that is punishable by death or confinement for more than 12 months, whereas a misdemeanor is a crime punishable by confinement for less than 12 months. In the criminal justice system, you will see that the more serious crimes, burglary, robbery, arson, murder, those are the felony crimes, whereas the misdemeanors are the simple assaults, the driving under the influence, things of that nature. that are less serious than the felony crimes. The sources of criminal law. Where do we get the criminal law from? Where do we get the laws from? Where do we get the penalties from, if you will? They come from early legal codes, common law, modern statutes, and the model penal code. We will focus more on modern statutes and the model penal code in this course as sources for criminal law. The next slide that I wanted to cover is reaching a verdict. It is very important for you to know that the burden of proof is very different in a criminal versus a civil trial. The burden of proof in a criminal prosecution first falls on the government. This means that it is the government's responsibility to prove that a person committed a crime. The prosecution must persuade the jury that the defendant should be held accountable. In a criminal case, the prosecutor must present proof beyond a reasonable doubt that the defendant committed the crime, which is roughly the same as saying, for example, there's a 95% certainty that the defendant committed the crime. That is beyond a reasonable doubt. That is the standard that the government must meet in order to get a guilty verdict in a criminal trial. In contrast, the burden of proof in a civil case falls on the plaintiff, the party who is bringing the suit. Also, the standard of proof in a civil trial is much lower than in a criminal trial. It is generally the preponderance of evidence, which is roughly akin to more certain than not, which equals about, let's say, 51%, which is much lower than 95%. So in a civil case, you just need to show that it is more certain than not. It is more likely than not, just 51%, that the defendant committed the act for which he is being sued. Whereas in a criminal case, the burden is much higher. It's beyond a reasonable doubt. Your book equates that to about a 95% certainty. And the reason for that difference is because in a criminal case, the defendant's liberties are at risk. The defendant risks losing his freedom, or in some cases where there's a death penalty, the defendant risks losing his life if he is found guilty. So for that reason, the burden in a criminal case is much higher than in a civil case. It's very important that you know the difference between these two burdens of proof. Now, there is some vocabulary that you should familiarize yourself with. We have the courtroom participants. We have the prosecutor, which is the individual who presents the government's case. And then you have the defense or defense attorney who represents the defendant and seeks to establish reasonable doubt in the minds of the jurors or in the judge in cases of a bench trial. Now, the difference between a bench trial and a jury trial is pretty obvious. In a jury trial, there are jurors who decide the guilt or innocence of the defendant. And in a bench trial, there are no jurors. The judge is the individual who decides the guilt or, well, I don't want to say innocence, but the judge is who would determine whether or not the defendant is guilty or not guilty. Now, I wanted to just take some time explaining this figure. It's labeled as figure 1.5 in your textbook. It is called the summary of steps in a criminal trial. And what it does here basically is it just diagrams the order in which a criminal trial will flow. So first, in the upper left, you have opening statements. That is when the prosecutor comes, gives his or her opening statement. Then, after the prosecutor is finished, the defense counsel will give an opening statement. Then, the prosecutor, the government, the state, they will first present their case in chief, their evidence. They would put on their witnesses, question their witnesses. Then the next step is cross-examination. The defense attorney then has the opportunity to cross-examine any of the prosecution's witnesses that they put on the stand. Then, after the defense attorney cross-examines the prosecution's witnesses, the prosecutor has an opportunity to re-question that witness, and that process is called redirect or re-cross-examination. It's not always mandatory, which is why it has in parentheses there as needed, because you only do that if it's needed. After that, the prosecution rests. They don't call any more witnesses. It is now the defense attorney's turn to put their witnesses on the stand. And then once they put their witnesses on the stand and they conduct their direct examination, then the prosecutor gets to cross-examine those witnesses just the same as what the defense attorney would have done when the prosecutor first put their witnesses on the stand. And then once that is done, I'm confused as to why the term rebuttal is listed here after the defense's response. But I'm guessing this is a situation where the prosecutor can then bring rebuttal witnesses to come in and rebut anything that any of the witnesses from the defense presented or said on the stand. So that's what that rebuttal pertains to. Any rebuttal witnesses that the state may call after the defense has presented its case. After that, we have final motions and closing arguments. The prosecutor will give the closing argument. Then the defense attorney would give a closing argument. After that, the judge will issue jury instructions to the jury. And these jury instructions oftentimes pertain to the law that the jury is bound to follow in reaching their ultimate conclusion. So that happens after the closing arguments. Then there is the juror deliberations. They go in the back, they deliberate, they look at their notes, they talk among themselves, they look at all the evidence. That's what's called deliberations. And as you may have seen, from various of these crime shows that are available to us now, deliberations can take anywhere from 1 hour to 2 hours to 1 week or 2 weeks, however long it takes for the jury to reach a verdict, which is the next step. And as you know, the verdict is either guilty or not guilty. And in the event the verdict is guilty and the defendant appeals that verdict, then you would have the post-verdict motions. This order of the criminal trial is something that I consider to be very important, which is why I took as much time as I did to highlight all of these steps. So please be aware of this order. Next is